Welcome back to the deep dive. Today, we're going deep on some pretty fascinating legal documents.
Oh, yeah.
Yeah, your study guide and
Okay.
textbook on the South African law of persons.
Right.
You might think, oh, that sounds a bit dry.
Uh-huh.
But trust me, this stuff affects everyone. It's like the secret code behind our legal identities.
You're absolutely right. This deep dive is all about understanding the building blocks of legal personhood in South Africa.
Okay.
Who's considered a person in the eyes of the law?
Right.
What rights and responsibilities come with that, and how it all changes throughout our lives.
Interesting. So let's start unpacking this. What exactly is the law of persons, and why should we care about it?
Well, the law of persons is a fundamental part of private law that deals with legal subjects, their legal status, and the factors that influence it.
Okay.
It's the framework for understanding how individuals interact with the legal system from birth, even before birth in some cases, to death.
So it's not just about legal theory. It has real-world implications for our lives.
Absolutely. It affects our rights and duties in areas like marriage contracts, inheritance, and even medical decisions. It's the legal foundation for so many everyday situations.
Got it. Now, I noticed that both documents mention different kinds of legal subjects. Can you break that down for us?
Sure, there are two main categories, natural persons and juristic persons.
Okay.
Natural persons are simply human beings like you and me.
Yeah.
Juristic persons are entities that the law treats as if they were people, organizations like companies, close corporations, and even certain types of trusts.
So companies have rights and responsibilities just like individual people.
Exactly. They can enter into contracts, own property, and even sue or be sued, all through the legal framework provided by the law of persons.
Wow.
It's how our legal system allows these organizations to function and interact with both individuals and other juristic persons.
That makes sense. But what about other things besides humans and organizations? Where do they fit into this legal picture?
Those would be considered legal objects.
Yeah.
Your textbook talks about two types corporeal things, which are physical objects like cars, houses, or even a book.
Right.
And then there's performance, which refers to actions or services.
Okay.
Think of it like this. You have a right to your car, corporeal thing,
Uh-huh.
and a right to a service you've paid for, say, getting your car repaired, performance.
Okay, so the law distinguishes between legal subjects who have rights and duties and objects, which are the things those subjects interact with. That's a helpful way to think about it.
Precisely, and this distinction is crucial for understanding how we can own, use, and interact with the world around us in a way that's legally recognized.
Now, I see that these documents also use terms like status, legal capacity, and capacity to act.
Yeah.
Can you explain what those actually mean?
Your status is your standing in the eyes of the law. Think of it as a snapshot of your legal position at any given time.
Right.
It's influenced by factors like age, marital status, mental capacity, and even insolvency.
Okay, so status is like a label that tells us where we stand legally. But it is about legal capacity.
Legal capacity is the ability to have rights and duties.
Right.
In South African law, every human being from the moment they're born has legal capacity. It's an inherent quality of being a legal subject.
So even a newborn baby has legal rights.
That's right. But having legal capacity doesn't mean you can exercise all your rights immediately. That's where capacity to act comes in.
So legal capacity is like the potential and capacity to act is actually being able to do something with it.
Exactly. Capacity to act is the ability to perform juristic acts, signing contracts, getting married, making a will, things like that.
Right.
It's the power to change your legal status or affect your legal relationships with others.
And as I'm sure you're about to tell us, capacity to act changes throughout life.
You got it. Age, mental capacity, and other factors determine your capacity to act.
Right.
A young child might have the right to own property legal capacity,
Yeah.
but can't legally buy or sell it on their own capacity to act.
Right.
That's why we have legal guardians for minors.
This is all starting to make a lot more sense. Now the first learning unit in my study guide dives into when legal personality actually begins.
Okay.
It seems like South African law has a clear answer to that question.
Yes. The documents state that legal personality begins at birth,
Okay.
but there are a couple of specific requirements that need to be met.
What are those requirements?
First, the birth must be fully completed, meaning the child must be completely separated from the mother's body.
Okay.
It's interesting to note that while severing the umbilical cord is common practice,
Yeah.
it's not actually a legal requirement for a birth to be considered complete.
That is interesting. What's the second requirement?
The second requirement is that the child must show signs of life after separation.
Right.
It used to be that the ability to live independently was considered important.
Mm-hmm.
However, that doesn't seem to be a legal requirement in South Africa anymore.
Okay.
Essentially, if a child is born and shows any sign of life, even for a short time, they are considered a legal person.
So the moment a baby takes its first breath, they are officially recognized as a legal person with rights and a legal identity.
Precisely. And that leads us to the next important step, registration of births.
Right. I see my study guide has a whole chapter dedicated to that. What's so crucial about registering a birth?
It's not just a formality. Registering a birth is a legal obligation for parents
Okay.
and is essential for establishing a child's legal identity and ensuring their access to basic rights.
Makes sense. So it's about more than just having a piece of paper.
Right.
It's about officially recognizing their existence under the law.
Exactly. And the process isn't always straightforward.
Right.
Your textbook outlines specific procedures for various scenarios.
Okay.
For example, there are different rules for unmarried parents cases where the parents want to change the child's surname, and even procedures for registering stillborn births.
It sounds like they've really tried to think of everything and make sure every child's birth is properly documented.
They certainly have, and it's a testament to how seriously South African law takes the concept of legal personality from the very beginning.
Okay, so we've covered what happens after a child is born, but what about before birth?
Right.
Does the law offer any protection or recognition to an unborn child?
This is where it gets really fascinating.
Okay.
Your textbook highlights a legal concept called the nasciturus fiction.
Good.
It's a way for the law to protect the interests of an unborn child as if they were already born.
Hold on, that sounds almost like legal science fiction. How does that actually work?
Imagine a situation where a parent dies before their child is born.
Okay.
The nasciturus fiction steps in to protect the child's potential inheritance rights.
Right.
It's like saying, we know you're not here yet, little one, but we're going to hold your place at the table just in case.
Wow, that's amazing. So even though they haven't been born, the law acknowledges their potential rights.
Exactly. It prevents them from being disadvantaged simply because of the timing of their birth. And the nasciturus fiction doesn't just apply to inheritance. It can also be used to secure maintenance payments if a parent passes away before the child is born, ensuring the child's financial needs are met even before they enter the world.
That makes so much sense. The law is like a forward-thinking guardian looking out for the child's best interests even before they arrive.
It really is, and it gets even more fascinating.
Oh, wow.
The textbook discusses a case, Chisholm v. East Rand Proprietary Mines, Ltd.,
Okay.
where a child was born after their father died in a mining accident.
Right.
The court ruled that the child could still sue for loss of support even though they weren't alive when the accident occurred.
That's incredible. So the nasciturus fiction can even protect a child from prenatal injuries.
It can, which highlights the extent to which the law tries to safeguard the interests of unborn children.
Speaking of safeguarding interests,
Okay.
what about situations where a pregnancy might not continue?
Yeah.
How does South African law approach the sensitive topic of termination of pregnancy?
As you can imagine, this is a complex and often debated area of
Yeah.
law. Your textbook explains that South African law,
What?
specifically the Choice on Termination of Pregnancy Act,
Right.
attempts to strike a delicate balance between a woman's right to choose and considerations for the fetus.
It must be challenging to find that balance respecting both the woman's autonomy and the developing life.
It certainly is. The law has evolved over time, and the textbook even mentions a case brought by the Christian Lawyers Association of South Africa where they challenged the constitutionality of the abortion laws.
Interesting.
This shows that the legal and ethical considerations surrounding termination of pregnancy are constantly being scrutinized and debated.
It's clear that this is an area of law with a lot of nuance and ongoing discussion.
Yeah.
Now, we've explored the beginning of legal personality in depth, but what about the end?
Right.
How does South African law actually define death?
That's a fundamental question, and it might surprise you to learn that South Africa didn't have a clear-cut legal definition of death until 2003.
Oh, really?
Before then, courts relied on medical evidence to determine death on a case-by-case basis.
So it was a bit of a gray area before 2003.
It was, but with the National Health Act, brain death became the official standard for determining death, at least in healthcare settings.
That makes sense. But what about situations where the circumstances surrounding a person's death don't fall neatly under the National Health Act's definition? Say someone goes missing in the wilderness.
You're right. There are situations where the act might not apply.
Right.
In those cases, courts can still rely on medical evidence and other factors to determine death, like in cases involving missing persons. This brings us to the concept of presumption of death.
Right. My study guide touches on that as well. What exactly is presumption of death and how does it work?
Essentially, if someone disappears and there's enough evidence to suggest they are likely deceased, the court can issue an order presuming their death.
Okay.
This allows for the deceased person's estate to be settled and for their loved ones to move forward legally.
What kind of evidence would convince a court to presume someone's death?
The court will look at various factors, including the length of time the person has been missing, the circumstances of their disappearance, any known dangers they might have faced, and any efforts made to find them. It's not just about the time that's passed. The context is crucial. Imagine someone goes missing while hiking a dangerous mountain trail.
Okay.
That scenario might lead to a presumption of death sooner than if someone simply stopped contacting their family.
So it's about piecing together a story based on the available evidence and determining the most likely outcome.
Exactly, and this leads us to the intriguing part. What happens if the presumed dead person suddenly reappears? Imagine coming back to find your assets have been distributed and your life has been declared legally over.
That would be a shock, to say the least.
Yeah.
So what happens then? Do they just have to accept the situation?
Not necessarily. While the presumption of death is a powerful legal tool, it's not irreversible if the person reappears. They can apply to have the order set aside. However, the legal process for unraveling the presumption of death can be complex and challenging.
That makes sense. After all life has moved on in their absence, and their reappearance would create quite a few legal tangles.
The law persons has to navigate these unexpected twists and turns, which is part of what makes it so fascinating.
Well, this deep dive has already uncovered some intriguing legal concepts. We've journeyed from the moment legal personality begins, even touching on the complexities of unborn children's rights, to the legal definition of death, and the fascinating concept of presumption of death. What other key areas of the law of persons are we going to explore?
Next, we're going to delve into the factors that influence legal status throughout life, like domicile,
Okay.
the impact of minority and mental capacity, and the concept of curatorship.
Sounds like we're just getting started. Let's take a quick break and then we'll dive into those factors that shape our legal identities. Okay, we're back and ready to explore those factors that influence our legal status throughout life.
Okay.
You mentioned domicile, minority, and mental capacity.
Right.
Let's start with domicile. What is it and why is it so important in the law of persons?
Domicile is a fascinating concept.
Okay.
It's the legal system that applies to your personal status in South Africa.
Right.
It connects you to a specific set of laws, which can have major implications for various aspects of your life.
So it's not as simple as just living somewhere.
Right.
I could live in Durban but have a different domicile.
Exactly. You could live somewhere permanently without actually being domiciled there.
Hmm.
It all boils down to intention, your genuine intention to make a particular place your permanent home.
Right.
Of course, actions speak louder than words. The law will consider your actual behavior and circumstances to determine your true domicile.
That makes sense. But why is this whole domicile thing so important? How does it actually affect me on a practical level?
Well, your domicile determines which laws govern things like marriage, divorce, inheritance, and even contracts. Imagine you get married in Cape Town, but are domiciled in Gauteng, which has different laws regarding the division of assets in a divorce.
Oh, right.
That could create some tricky legal situations.
I see. So domicile is like having a legal home base that determines which set of rules applies to you, even if you're physically somewhere else. It's like having a legal GPS system for your personal status.
That's a great analogy.
Uh-huh.
It highlights the importance of understanding domicile, especially if you're moving between provinces or have ties to different legal jurisdictions.
Now let's move on to another factor that affects legal status, the distinction between children born to married and unmarried parents. My study guide points out that this is a key area in the law of persons. Can you shed some light on this distinction and why it matters so much?
Absolutely. The legal status of a child can differ significantly depending on whether their parents were married at the time of their birth.
Right.
Historically, there were major differences in the rights and responsibilities afforded to children born within and outside of marriage. However, South African law has evolved significantly in recent years to try and level the playing field.
That's good to hear. So what's the current legal position for children born to unmarried parents?
The Children's Act of 2005 has been instrumental in equalizing the rights of all children. The mother of a child born out of wedlock automatically acquires full parental responsibilities and rights. The father's rights, however, depend on a few factors outlined in the Act.
What kind of factors determine the father's rights in these cases?
Well, if the father consents to be identified as the father on the child's birth certificate, or if he lived with the mother at the time of the child's birth, he automatically acquires full parental responsibilities and rights.
So there are clear legal pathways for unmarried fathers to establish their rights and responsibilities from the outset.
Exactly. And even if those criteria aren't met, the father can still acquire full parental rights and responsibilities if he can prove that he's contributed to the child's upbringing and maintenance for a reasonable period.
Okay.
The law recognizes that a father's role isn't solely determined by marital status.
That's a more inclusive approach, acknowledging the importance of both parents in a child's life, regardless of their marital status. What about situations where paternity is disputed? How does the law determine who the father is in those cases?
That's where things can get a bit more complex. Your textbook goes into some detail about proof of paternity in the past. It was based on the mother's word. But advancements in technology, particularly DNA testing, have revolutionized how paternity can be determined.
So DNA testing is the gold standard now.
While DNA testing is highly accurate and often conclusive, the law still recognizes other forms of evidence to prove paternity. This could include evidence of sexual intercourse at the time of conception, admissions of paternity by the alleged father, or even physical resemblance between the child and the alleged father.
It sounds like proving paternity can involve a whole range of evidence, with DNA testing being the most scientifically reliable, but not the only factor considered.
Precisely, the courts often have to weigh different types of evidence and consider the best interests of the child when making a determination about paternity. And as you can imagine, the legal consequences of such a determination are significant, affecting child maintenance, inheritance rights, and parental responsibilities.
It makes sense that the courts would take a holistic approach, considering all the evidence and prioritizing the child's well-being in these situations.
Absolutely. And it highlights the importance of legal expertise in navigating these complex family law matters.
Now let's turn our attention to another significant factor that influences legal status: being a minor Fazali. My study guide emphasizes how minority status affects a person's legal standing. Can you elaborate on that for us?
Of course. In South Africa, a person is considered a minor until they turn 18.
Right.
The law recognizes that minors need special protection and might not possess the maturity or judgment to make certain decisions that could have long-term legal consequences.
It's like they're still learning the ropes of legal adulthood. So how does the law protect minors?
The law places restrictions on their capacity to act.
Okay.
For instance, minors generally can't enter into contracts without the consent of their guardian.
Right.
They also cannot get married, make a will, or consent to medical treatment without parental or guardian consent. These safeguards are in place to prevent them from making decisions they might later regret.
So there are a lot of legal safeguards in place to protect minors from making decisions that could potentially harm them. But what about situations where a minor might need to enter into a contract, say for essential goods or services? Are there any exceptions to these restrictions?
Yes, there are some exceptions. The law recognizes the need for minors to have some degree of autonomy, particularly when it comes to necessities. A minor can enter into contracts for essential goods and services like food, clothing, or medical care without needing their guardian's consent.
That's a good point. It wouldn't be fair to prevent them from accessing basic necessities just because they haven't reached the age of majority.
Yeah.
What about situations where a minor misrepresents their age to enter into a contract?
That's a tricky situation.
Yeah.
While the law generally protects minors from exploitation.
Right.
If a minor misrepresents their age and enters into a contract, they might still be held liable in certain circumstances. The courts will consider the specific facts of the case and whether it's fair to hold a minor accountable despite their age.
So there's a balance between protecting minors and recognizing that they also have a responsibility to act honestly in legal matters.
Exactly. It's about finding that middle ground where minors are shielded from undue harm while also learning the importance of responsible conduct.
Now, my study guide mentions that a minor's legal status can change through a process called emancipation.
Right.
What exactly does that mean, and how does it work?
Emancipation is a legal process that grants a minor certain adult rights and responsibilities before they reach the age of majority. It's a way for them to gain more independence and control over their own affairs.
So it's like a fast track to legal adulthood.
In a sense, yes, but it's important to note that there are different types of emancipation, some more comprehensive than others. Some might be limited to specific areas, like allowing a minor to run their own business, while others could grant broader legal capacity similar to that of an adult.
How does a minor become emancipated?
There are a few pathways to emancipation. One of the most common is through marriage.
Okay.
Once a minor is legally married, they are often automatically considered emancipated. Another way is through a court order. If a parent or guardian believes a minor is mature enough to handle their own affairs, they can apply to the court for an emancipation order.
So the court has the final say.
Yes, the court will carefully consider various factors before granting an emancipation order. They'll assess the minor's maturity level, their ability to support themselves financially, and whether emancipation is truly in their best interests. It's a significant decision with lasting legal implications.
It makes sense that the court would take a cautious approach, ensuring that emancipation is truly beneficial for the minor involved. What about situations where a minor might not be emancipated, but still needs to participate in certain legal activities?
That's where the concept of assistance comes in.
Okay.
A minor can enter into a contract or participate in other legal activities with the assistance of their guardian. The guardian essentially provides their legal consent and oversight, ensuring that the minor's actions are protected and that their interests are represented.
So it's like having a legal safety net for the minor, allowing them to take part in certain legal activities while still having the guidance and protection of their guardian.
Precisely. It's a way to balance the need for protection with the recognition that minors are developing individuals who need opportunities to learn and grow within a structured legal framework.
Now moving on to another complex area. How does mental illness factor into legal status and capacity?
That's a crucial area to address.
Yeah.
Your textbook explains that mental illness can impact a person's capacity to act. It recognizes that someone experiencing mental health challenges might not have the necessary judgment or understanding to make sound legal decisions, potentially putting themselves at risk.
So the law steps in to protect them in these situations.
Exactly. If a court deems someone mentally ill,
Right.
they can be placed under curatorship.
Okay.
A curator is then appointed to manage the person's affairs and make decisions on their behalf, ensuring their well-being and protecting their interests.
It's like having a legal guardian for an adult who needs support in managing their life due to mental health challenges.
That's a good way to put it. The curator acts as a responsible steward, safeguarding the person's assets and making decisions that align with their best interests.
What determines whether someone is declared mentally ill by the court and placed under curatorship?
It's not a decision taken lightly.
Right.
The court requires compelling evidence, usually in the form of medical reports from psychiatrists or psychologists, that confirms the person is suffering from a mental illness that significantly impairs their ability to manage their own affairs. The court will also consider evidence from family members, friends, and other relevant individuals who can shed light on the person's condition and their ability to function independently.
So it's not just about having a mental health diagnosis. It's about the impact that diagnosis has on their capacity to make sound decisions and manage their life effectively.
Exactly. And it's important to remember that being declared mentally ill and placed under curatorship doesn't automatically strip a person of all their rights.
What kind of legal protections are there for people declared mentally ill?
The Mental Health Care Act of 2002 is crucial in this regard. It outlines numerous safeguards to ensure people with mental illness are treated with dignity and respect. They have the right to participate in decisions about their care and treatment, and they cannot be involuntarily hospitalized or subjected to treatment without due process.
It sounds like South African law aims to strike a balance between protecting people with mental illness and respecting their autonomy, recognizing that they still have fundamental rights that need to be upheld.
Absolutely. And it's an area of law that's constantly evolving as our understanding of mental health grows and as we strive to create a more just and compassionate legal system for everyone.
This deep dive has uncovered some really important factors that impact legal status in South Africa. We've gone from domicile to the rights of children born to unmarried parents and the legal implications of minority status and mental illness. Is there anything else we should touch on before we wrap up this deep dive into the law of persons?
There are a couple more fascinating concepts that can impact a person's legal capacity and status, prodigality, and insolvency.
Okay, I'm definitely intrigued. Let's explore those concepts next.
Okay, we're back and ready to tackle those last couple of concepts. You mentioned prodigality and insolvency. Let's start with prodigality. What exactly does it mean for someone to be declared a prodigal in South Africa?
Well, prodigality is a fascinating legal concept.
It deals with individuals who exhibit a pattern of reckless spending habits.
Okay.
It's not just about being a bit careless with money. It's about a persistent inability to manage finances responsibly to the point where it threatens their own financial security and potentially the well-being of those dependent on them.
So we're not talking about someone who splurges on a fancy dinner once in a while. It's more about a serious pattern of financial mismanagement that puts their entire estate at risk.
Exactly. Think of someone who constantly makes impulsive purchases, racks up huge debts, or gambles away their savings. Despite the negative consequences, they might have a genuine inability to control their spending, even when it's clear that their actions are detrimental.
So what happens if someone is officially declared a prodigal by a court? What are the legal implications?
Well, if a court declares someone a prodigal, their capacity to act specifically in financial matters is restricted. The law recognizes that these individuals need protection from themselves and from those who might try to exploit their financial vulnerability.
Okay, so their ability to make financial decisions is limited. What does that look like in practice?
The court will typically appoint a curator to manage the prodigal's finances and oversee their estate.
Yeah.
The curator's role is to ensure bills are paid, assets are protected, and the prodigal doesn't fall deeper into debt. They act as a sort of financial guardian, making responsible decisions on the prodigal's behalf.
It makes sense. It's like a legal safety net to prevent them from financial ruin. But doesn't restricting someone's financial autonomy seem a bit, well, extreme?
It's a delicate balance.
Right.
On one hand, everyone has the right to make their own choices, even if those choices aren't always the most prudent.
Yeah.
But on the other hand, the law also has a duty to protect individuals from harm, especially when their actions pose a significant risk to themselves or others. In the case of prodigals, their uncontrolled spending can have devastating consequences, not just for themselves, but potentially for their families and dependents as well.
That's a good point. So it's not about punishing them. It's about trying to prevent them from causing further harm while still acknowledging their inherent dignity and rights.
Exactly. And while their financial autonomy is restricted, it's not completely removed. The curator works with the prodigal, providing guidance and support to help them develop better financial habits. The goal is to eventually restore their full capacity to act once they've demonstrated an ability to manage their finances responsibly.
That's a more nuanced approach than I initially imagined. It's not just a label, it's a process of support and rehabilitation.
You've got it. Now, shifting gears a bit, let's discuss insolvency, which is a broader legal concept that can also significantly impact a person's legal status.
Okay, you mentioned insolvency is different from prodigality. What exactly sets it apart?
Insolvency is a legal state where a person is unable to pay their debts, unlike prodigality. It doesn't necessarily stem from reckless spending. It can be caused by a job loss, business failure, unexpected medical expenses, or any number of factors that lead to financial hardship.
So it's more about the inability to meet financial obligations, regardless of the reason behind it.
Precisely. And the legal consequences of insolvency can be quite significant, particularly for the debtor, who faces various restrictions and procedures designed to address their financial situation.
What kind of legal procedures are we talking about?
Well, when someone is declared insolvent by a court, their estate is placed under the control of a trustee. The trustee's job is to gather the insolvent person's assets, sell them if necessary, and use the proceeds to pay off their creditors in a fair and orderly manner.
It sounds like a complex process with a lot of legal intricacies.
It can be, but it's a vital part of our legal system. Insolvency law aims to strike a balance between protecting the rights of creditors who are owed money and providing a pathway for debtors to get a fresh start financially.
It's interesting how the law of persons touches on so many aspects of our lives, from birth to death and everything in between.
It really is.
We've explored concepts like legal personality capacity to act domicile, the rights of children, and even the legal implications of mental illness, prodigality, and insolvency. It's amazing how these seemingly abstract legal ideas actually shape our experiences in the real world.
It's truly fascinating, isn't it?
Yeah.
The law of persons isn't just about dry legal principles. It's about the very essence of our legal existence, defining who we are in the eyes of the law, and outlining the rights and responsibilities that come with being a part of a society governed by rules and regulations.
You've made this deep dive into the South African law of persons incredibly insightful. Thank you for sharing your expertise with us.
My pleasure. It's been a great discussion.
And thank you, listeners, for joining us on this fascinating journey into the legal foundations of personhood in South Africa. We hope you've gained a deeper understanding of this complex yet vital area of law. Until next time.